Good afternoon. I see people arriving and coming into our proverbial auditorium. Please do me a favor. As you come in, there's that chat bubble at the bottom of your screen. Just say hello and where you're from so we can get an idea from which parts of the country people are joining us today. In that chat, just say, there we go. Hi from Cape Town. There we go. Centurion Bev, welcome. The Joburg, Wellington, my gosh, there it's filling up nicely from all over. The Pretoria, Durban, Somerset. Oh, that's gorgeous. Lowenhale and Roodepoort. Paul Kurumon in Pangeni, Cape Town. Is it marvelous? I've said this in the past, but I mean, pre-COVID, which is all of 5 years ago, we would have had to go to a different venue in every single city to be able to present something like this. And here we are scattered all around South Africa being able to attend. And that's the wonder of technology. And that's one of the things we're going to be showing you today is the wonder of technology and how technology is changing all our lives. That's really fabulous. It's 14:31. We're going to wait another maybe a minute or so just for more people to come into the room. There we go. Marble Hall in Limpopo. Welcome. Welcome. Hartenbos, right? People from the Binneland and the sea. There's Pretoria and Hopefield. Welcome, everybody. It's really nice to see this variety of South Africa being well represented. Welcome. Okay, we'll wait a couple of more seconds. There's St. Francis Bay. I'm glad to see that you're working on a Thursday afternoon in St. Francis Bay. Yeah, yeah. London, there was a London. Welcome, London. You see, even the people in the UK need the services of the South African team. Welcome, London and Cape Town. Right, it's 14:32. Let's get going. I know there's still some people streaming into the room, but we are pressed for time and we have our constraints. So let's move on. I'm going to start off with a little story. When I was doing my articles, I was doing a number of property transfers at the time, and my principal was a conveyancer. And one of the first questions he asked me, he said, George, when you receive a new transfer instruction, what's the very first thing that you do? And I was racking my brain. I was thinking, well, I do a property search. I open a file. I acknowledge receipt. I acknowledge receipt to all the parties and so on. And he just nods his head. He says, no, 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 no. That's not what you do. The first thing that you do is you look at the purchase price because that will determine how big the fee is going to be. That's the first thing you do. And only then do you start doing all these other things. And then, of course, the next thing that happens is you start looking at other things in the property transaction. You look at the parties, you look at the marital status of the parties, you look at the causa, and all of this determines the complexity of your transaction. Are the parties married in, out of community of property, companies, trusts, and the like? Is the causa maybe complicated? The property description, all of those things have this real influence on the complexity of your transaction. And the thing that brings all of these complexities together and more are deceased estates. Now suddenly you have a combination of all these things. Now suddenly your causa isn't necessarily a purchase price that you can see clearly on the deed of sale, but it's a will is your causa, or maybe there's a sale out of the estate. So there are lots of legal principles at play here and lots of practicalities and all sorts of requirements behind the sort of mysterious Section 42 of the Administration of Deceased Estates Act. So today we're going to unpack that stuff, all those complexities, pull all of those together, and then to my first point, show you how technology takes away a lot of that fear, complexity, and uncertainty, and how we bring those things together by using Lexis Deceased Estates as the platform with which to wind up your deceased estates, and how those marry up together with Lexis Convey, which ultimately does the smooth conveyancing process afterwards. So to take us through all of this, some of the legalities and complexities, and then ultimately the simplifications through the technology. I'm joined by my colleagues today. Gavin Botha, he's down in Cape Town. Jamie Lee's down in Cape Town, and Judy's also in Cape Town. I'm in Johannesburg. But welcome to my colleagues. They're going to take us through this process. I want to ask you, at the foot of your screen, not that chat where we all said hello from the different parts of. Hi, Boitumelo from Joburg. Welcome. Um, Not in that chat, but if you've got any questions, please use the Q&A. You'll see a few little blocks to the right of your screen is a Q&A block. Feel free to ask questions there. Our resident expert, Jamie Lee, is going to try and answer the questions on the fly, as will I, but we will compile all of those as we go along. Importantly to remember, we will be sharing the recording of the session. So you needn't ask, please, can you share this? We will be sharing this with you. So bear that in mind. That's the sort of admin out of the way. One last thing. Towards the end, Gavin will give you a heads up. A poll will pop up on your screen with some questions which we please ask that you answer. It's very important for us for all sorts of purposes, but please complete that for us. Gavin, I've rambled enough. We need to hear about the procedural requirements and the complex principles behind Section 42. I'm going to hand over to you, Gavin, to take us through this. Thank you very much.
Thank you so much, George.
Gavin.
Lovely introduction and a lovely set of the scene. I am not going to spend too much time elaborating. I'm going to jump in, share my screen, and put on my camera because it's quite distracting while we've got some slides up. You can just let me know as soon as you see a view of my screen on your side.
I'll tell you, not quite, it's not there yet. Okay, it's loaded, Gavin. Just put it onto presentation mode.
And then I'm just going to hide all of these additional bubbles. So we have the full real estate going over here.
There we go. We're on presentation mode. All yours, Gavin. Thank you.
Thank you, George, and welcome to everyone. Like George mentioned, conveyancing can be quite a complex process, as I'm sure most of us know already. Today, we're going to try and discuss Section 42 of our Administration of the Estates Act, just to simplify two processes we often see in conveyancing a bit for our attendees today. So let's jump in with just a quick overview of what we'll be discussing today and also what we'll be looking at in terms of our LexisNexis products. So first up, we'll just be looking at a quick overview, an understanding of what a fixed property is in terms of a deceased estate, and also look at some examples of which of these assets are considered fixed properties. We'll then go over into our legislative framework, where we'll look at the relevant case law and legislation that play a role when we are dealing with these fixed properties and our Section 42 transfers. And then we'll look at them separately. So first off, we'll look at our property transfers to heirs in terms of Section 42(1), and then we'll look at our sale of those properties to third parties in terms of Section 42(2). And then we'll also look at Section 21 just to see how different we handle these things differently when we have joint ownership in the property. It does complicate things a bit, but it does make it easier if we understand how to apply Section 21. And then we'll move over to a practical example. So like George said, LexisNexis does have products to help make this process much easier. And we've got two products that we'll highlight at the end of our session, which will be our Lexis Deceased Estates platform, which helps us with the administration of the estate, as well as Lexis Convey, which helps us with the transfer aspects of those fixed properties. So let's jump into that. First, we'll look at just a better understanding of what a fixed property is. For this, we can look at our Administration of Estates Act, which guides us on a better understanding of fixed property. So in terms of our Administration of Estates Act, a fixed property refers to immovable property that the deceased owned during their lifetime, which now forms part of their estate's assets. Okay, so here we have to further define immovable property. Immovable property then is any property that can't be moved from one place to another. So it typically includes land or anything that's permanently attached to that land, such as buildings or permanent structures. And then our Administration of Estates Act further defines fixed property to include any land and any permanent structures on it which are inherently immovable by nature. So quite easy to understand here when we're dealing with fixed property. It's properties that can't be moved easily, that are usually affixed to a certain property or piece of land. We're not looking at vehicles, we're not looking at shares, we're looking at properties, homes, whether they are conventional, sectional, or anything of the sort. That is what we're dealing with when we are looking at Section 42 of our Administration of Estates Act. This can include various types of properties. So just to name a few examples of those types of properties, of course, we have our conventional properties, which is our standalone residential homes, plots of lands, farms, so forth, anything that we usually refer to when we think of a property or piece of land. We do also have sectional title properties, which we can transfer or sell in terms of Section 42. A sectional title property is then a unit within a multi-unit property, such as a townhouse or an apartment, where ownership is shared between other owners. We can also look at retirement village property, so property which is designated for retirement living. And we can also look at timeshare properties, so property ownership rights granted for a specific period, allowing shared use by multiple owners, typically also known as our vacation properties. So these can also, of course, be transferred in terms of Section 42 of our Administration of Estates Act. So why is it important that we understand the processes in terms of Section 42? So it's quite a complex process to understand. Once you get a hang of it, it's easy, but timeline-wise, if you don't follow the right steps at the right time, it could lead to delays in both the administration process as well as the registration process of that property or the transfer process of that property, which of course leads to additional costs that we'd rather not incur during this administration process, especially since we know how lengthy that process already is with our current framework. So what legislation plays a role then? Of course, like I mentioned, we're dealing with Section 42 of our Administration of Estates Act. So that would be our first piece of legislation that we look to when it comes to these types of transfers. Some sections that we need to highlight in the Administration of Estates Act is, of course, Section 13, which requires that all immovable property in a deceased estate be administered by an executor who has the authority to distribute, sell, or transfer the property. So here we can take this section apart for a bit. It means that when we are dealing with a fixed property in an estate, it's often that we will have to appoint an executor to deal with that fixed property. So not all the time. It is possible where we have a property that's obviously less than 250,000 Rand in value, where it's a Section 18.3, and we have a master's representative dealing with that property. But because of the complexity of these kinds of transfers, the master will often direct that an executor be appointed instead. And they will also often direct that the executor be an admitted attorney, or that you be, if you are a family member that is acting as the executor, that you be assisted by an attorney throughout this process of transferring the property. So it also means beyond that, that the executor has certain rights and responsibilities when dealing with this property. They have the authority to distribute it in terms of the will or the Intestate Succession Act, and they can also elect to sell or transfer that property depending on the specific circumstances of that estate. We'll delve into that in a bit more detail as we move through our slides, but just something to keep in the back of your mind for now. The executor has the option to elect whether to sell or transfer the property. Okay, then of course, our main sections for today would be Section 42.1 and Section 42.2. And these sections outline the process that we follow when we're either selling a property from an estate or transferring a property from an estate in terms of our will or our Intestate Succession Act. Section 47 also just speaks to Section 13 and again addresses the power of the executor when selling immovable property, particularly when it's needed to settle debts, to distribute the estate's assets, or to distribute the assets amongst heirs. So if ever you wonder what the powers of the executors are in terms of fixed property in an estate, you can look to Section 47 of the Administration of Estates Act, which outlines that very clearly for us. Of course, because we're dealing with property, our Deed Registry Act also comes into play. And in terms of Section 16 of our Deed Registry Act, registration of immovable property or any other real rights in land are not transferred until formally registered in the Deed Registry. So even if we move through the process in terms of the Estate Administration Act, we also need to keep in mind that we need to follow the processes in terms of the Deed Registry Act for that property to be formally registered. Section 45 of our Deed Registry Act also specifies that a certificate of consent must be obtained when immovable property is transferred to heirs. So this links back to Administration of Estates Act. So here we can kind of see the interplay between these two acts. So we've got Section 16, which says we need to follow the proper process in terms of our Deeds Registry Act. And then we've got Section 45 of our Deeds Registry Act saying we need to make sure we follow the process in terms of our Administration of Estates Act to obtain the proper certificates or consent from the master. So of course, we also look at our Intestate Succession Act. Very often in South African estates, we find that there is not a valid will or a signed will. So we have to use our Intestate Succession Act rules. But whether we are looking at a will when transferring or selling the properties, or we're looking at the Intestate Succession Act, we'll follow the same process set out in terms of Section 42. Some important case law we need to consider that also just back the specific sections we looked at now is Oshry versus Feldman, which is a 2010 case. And in this case, there was just clarification on the rights of beneficiaries and the role of an executor when distributing fixed property. And it just reinforced the notion that it remains the executor's choice when it comes to deciding whether a property needs to be sold or whether it can be transferred in terms of the Intestate Succession Act or the will in place. And then we can also look to estate marks versus the master. And in this case, the court addressed the master's role in consenting to these transfers. To elect what to do with that specific movable property, but it also needs to be consented to by the master. They have a role of oversight in the decision that the executor makes. And it also then emphasizes that the executor must follow the strict process put in place in terms of Administration of Estates Act to get that master's consent and avoid any missteps in the process that could later lead to the transfer being invalidated. And lastly, we also look at Nyewa versus the Road Accident Fund and another. And here they looked at the rights of the heirs when it comes to immovable property. And it was outlined that the rights of the heirs do not become enforceable until the property is transferred to them or registered in their name. So it just reiterated that the decision lies with the executor. Just because the will states that the property needs to be transferred to the heirs does not mean they have a right in the property the moment that will comes into play. They only have that say or that right in the property when it gets registered in their names after the process in terms of Section 42 has been followed. Okay, so just to give a quick summary there, our executor in terms of our legislation and our case law has an option and authority to elect how to deal with our fixed property, whether it's in terms of a will or the Intestate Succession Act. When we are dealing with a deceased estate, they can elect to either sell the property or they can elect to transfer the property. Of course, we have certain justifications that need to be in place to sell the property if it's specified that it needs to be transferred, such as a shortfall in the estate and the asset needs to be sold in order to cover that shortfall. Secondly, we need to understand that the heirs do not have an enforceable right in that property up until the date that it's transferred. So it remains the decision of the executor on how to deal with that property up until it is transferred to the heirs, and then they have a say in how to deal with that specific property. And lastly, we need to understand that the master has an overreaching role here, where the master outlines the process in terms of how to deal with these properties in a deceased estate. And you also need to get the consent of the master in order to justify the decision you've made on how to deal with this property in the estate. Okay, so now that we have a better understanding of our legal framework and our roles and responsibilities when dealing with our properties in an estate, let's focus on our specific sections. So the first section that we're going to focus on is section 42.1. So section 42.1 has bearing when we transfer fixed property to an heir as set out in a will or in terms of the Intestate Succession Act. Okay, so it has bearing when any endorsement is made under section 45.1 or 39 and 40 as well of the Alienation of Land Act or the Deeds Registry Act. And in terms of section 42.2, there are certain requirements put in place that we need to adhere to at the Master's Office side of things before we can lodge in the Deeds Office for that deed to be registered in the heir's names. So on the left-hand side, we've got the requirements set out that the estate administrator or the executor needs to follow before instructing the conveyancing attorney to proceed with lodgement in the Deeds Office. So you'll see there's a certificate required. The certificate is drafted and signed by the conveyancer before it's lodged at the Deeds Office. And in the certificate, there are certain confirmations that need to be confirmed by the conveyancer. And of course, with these confirmations, there are certain, we can say, milestones that need to be reached and confirmed before the conveyancer can attest to that. So the first of those milestones would be that the property is being transferred in terms of the will or the Intestate Succession Act, where we do not have a valid will. Secondly, that the property has been properly recorded and described in the liquidation and distribution account. So just a tip here as well, from the outset, when you are reporting to the master, ensure that you describe that property the way it would be described in the title deed. So you can describe it that same way in your liquidation and distribution account. So by the time it gets to the master's office, all those descriptions of the property align with one another, and there's no discrepancies in the way you've described that property in any of your documents from the master's office through to the deeds office. Thirdly, we need to confirm that the L&D account has lain for inspection, and that means it has been advertised in terms of section 35 of our Administration of Estates Act, and also that the L&D account has been approved by the master. So those steps, of course, go hand in hand, because once the account gets approved by the master, we can advertise for inspection in terms of section 35. So we know as well in the administration process that advertisement in terms of section 35 is towards the end of our administration process. So it's also at the time where we are almost ready to distribute all of our assets in terms of our liquidation and distribution account, because once that inspection period has passed, then we can distribute. We usually get our masters go ahead to distribute if we did not have any objections from the creditors during that 14 or 21-day period. I can't remember the exact time frame now. But once that's passed, then we should also be in a position to lodge so we can distribute and avoid any delays at that point. Okay, so there are instances, of course, where the certificate is not required. As we know, there are always exceptions to the rule. So we've listed 2 exceptions here. If we are dealing with a Section 18.3 estate, of course, we have no liquidation and distribution account, so there's no need for us to lodge the certificate in terms of Section 42.1, confirming that the liquidation and distribution account is laid for inspection and that it has been approved by the master. Because we have no liquidation and distribution account, it's very seldom that we are able to use the specific instance where we don't have to lodge the certificate, because it's unlikely that a property will have a value less than 250,000 Rand. And even when it does, the master will almost always direct that an executor be appointed because of the complexity of the process when transferring property. The second exception we have to this rule is when we are doing a cession of a mortgage bond. So when we are ceding mortgage bond, because mortgage bonds are excluded from the definition of immovable property under the Deeds Registry Act, they're therefore excluded from the operation of Section 42.1. So there's no need for us to lodge the specific Section 42.1 conveyance certificate when we are dealing with mortgage bonds. Okay, so on the conveyancer side, how do we deal with the Section 42(1) transfer in terms of our Administration of Estates Act? Of course, we can understand that the document that we have just referred to is going to be one of our requirements in the deeds office as well. So we've listed it right at the top there. When you're lodging with the deeds registry, you need to lodge that conveyancer certificate completed by the conveyancer and confirming all of the points that we've just listed. We also then lodge our original title deed, our usual power of attorney, which will be signed by our executor. We also include our transfer duty exemption certificate because we are transferring to heirs in terms of the will or the Intestate Succession Act. This transaction will be exempt from transfer duty. However, if we are transferring to a third party in terms of the will, we will have to apply for our transfer duty receipt. So also important to note, it's important to understand who the property is being transferred to, whether it is an heir or whether it is a third party. Okay, then of course we also lodge our rates clearance certificate from our local municipality. An additional document that we don't usually lodge in our transfer process is a certified copy of the will as well. So we're going to have a certified copy of the will from the master's office, which was accepted by the master as the original will. And in the case of an intestate succession, an affidavit from the executor as proof that the deceased died intestate. Okay, so why do we lodge the copy of the will or an affidavit by the executor of proof that there's an intestate estate? It's so that the council can be properly identified by the deeds office. Okay, so we also, if we are looking at a bond, the bond and consent from the creditors, if applicable, also needs to be lodged where we lodge at the deeds office. So as you can see, it's important we have two sets of documents that we need to prep before we get to transfer at the deeds office or lodge at the deeds office for registration. It's our conveyancer certificate, which we can only get towards the end of our administration process once we've advertised in terms of Section 35. And then our certified copy of the will, which is also always advised that you apply for that at the master's office earlier rather than later. Don't get to the point where you've advertised in terms of Section 35 and now you applied for a certified copy of the will. That's going to delay the process unnecessarily. You could have applied for that already when you lodge that L&D account initially for inspection, for approval by the master. And of course, also remember an affidavit when we're not dealing with the will, just to outline that the estate is indeed, the deceased did indeed die intestate. Transfer duty implications when we're dealing with Section 42(1), like I've mentioned, it's usually a transfer to heirs or legacies, which are typically exempt from transfer duty in terms of Section 9(1)(e) of the Transfer Duty Act. However, we still apply to SARS for our transfer duty exemption certificate. So in short summary, in terms of Section 42(1), we do require that the L&D account had lain for inspection and been approved by the master. It should be properly listed in our liquidation and distribution account inventory the same way it would be described on our deed. And it should be in accordance with the will or the Intestate Succession Act. So it should follow the same distribution as is outlined in the will or as outlined in our Intestate Succession Act for it to be a Section 42(1). And this needs to be confirmed with a conveyance certificate that we lodge at the deeds office together with a certified copy of the will and our other supporting documents we usually lodge in the deeds office for registration. We do have two exceptions, Section 18(3) estates and when we are ceding a mortgage bond. Next up, we're going to have a look at Section 42(2). So Section 42(2), quite a different process, quite easy to distinguish the two processes from one another as well, where Section 42(1) dealt with the transfer to heirs in terms of the will or the Intestate Succession Act. Our Section 42(2) deals with the sale of the fixed property to a third party, such as a purchaser rather than an heir. So one will deal with the sale, the other one will deal with the transfer in terms of the will to an heir. So this process requires the Master of the High Court to consent to the sale out of the estate, because of course it won't be in terms of the will or the Interstate Succession Act. The executor in this instance would have elected to sell the property either because the heirs consented to the sale of the property or because it was necessary to sell the property to cover the debts in the estate or the shortfall in the estate. How do the requirements differ from a Section 42(1)? In this instance, the requirements are more direct with the Master of the High Court. So it's more of a direct application to the Master of the High Court. And here we kind of require documents from the conveyancing side of the process first before we can request the consent from the Master at the Master's office. So what do we lodge with our Master's office to get this consent? There's a set application form, Form JM33, which is signed by the executor. And on this form, we formally request the consent of the master to the sale of the property out of the estate to a third party. Along with the Form JM33, you have to obtain and lodge with the master written and signed consents from all heirs to authorize the sale of the property. We also have to certify a copy of the deed of sale and lodge that with the master's office so that the master can confirm the agreement between the executor and the third-party buyer outside of the estate. And then, of course, we lodge our power of attorney, which we get from our conveyancing attorney. And this power of attorney will eventually be lodged in the deeds office for registration. So make sure that the descriptions of the parties or the property is correct on that power of attorney before you lodge it with the master for the consent, because having to lodge it again due to a small change in a naming convention or because of the incorrect identity number is going to be a costly exercise that's also going to delay the process unnecessarily. So we lodge our power of attorney, our written consent from our heirs, and our Form JM33 with the master. And if we have not yet lodged our liquidation and distribution account, we lodge an affidavit just stating that the estate is solvent or insolvent, depending on the reason for us selling that asset. If we've lodged our liquidation and distribution account, it will obviously already be clear to the master by looking at our L&D account. The master then reviews these documents, puts a stamp on the power of attorney, returns that to the estate administrator or the conveyancing attorney to lodge at the deeds office. Okay, so the process is quite different here. Unlike Section 42(1), we don't have the requirement with a Section 42(2) transfer that the L&D needs to have lain for inspection or advertised in terms of Section 35. So we can transfer before our liquidation and distribution account as lain for inspection in terms of Section 35. So it allows for a faster transfer process in cases where the sale is essential to meet our estate needs or to pay off our creditors or any shortfall we have in the estate. What then is our conveyancer's role in terms of the Section 42(2)? So for our conveyancer, they of course need to get the property registered as soon as possible so that the funds can be transferred into the estate to settle any outstanding debts and distribute the remainder amongst our heirs or beneficiaries. Which document do they require? Of course, they require the master's endorsed power of attorney. So confirming that there's no objection to the sale, our usual original title deed, a certified copy of the deed of sale. So because we're not dealing with a will and we're not transferring in terms of the will, we need to confirm the causa at the deeds office. So the causa in this instance will be our deed of sale. So we need to lodge a certified copy. It can be certified by the conveyancer just to confirm the terms of sale and the agreement between the executor and the third-party buyer outside of the estate. Of course, we lodge our transfer duty receipt in this instance. In most instances, it will be a transfer duty receipt. There will be instances where we could, for example, be selling to a spouse who's not a nominated heir, where we might have an exemption certificate as well. Our user rates clearance certificate, and our bond or consent from creditors where the property is bonded. like I've mentioned with the transfer duty implications, if it's a third party, transfer duties will apply. It differs if it's an heir in terms of section 42.1, which is generally exempt. So just to distinguish a section 42.2 from a section 42.1, 42.1 is a transfer to an heir. There we do a conveyance certificate, and then we have to wait for the L&D account to be advertised in terms of section 35 and had lain in for inspection before the conveyancer can issue out that certificate. So that transfer usually happens just before we distribute at the end of the administration process. With a section 42.2 transfer, it's usually a sale outside of the estate to a third party. And here we require the master's prior consent before lodging in the deeds registry. We do this by submitting consents from all of our heirs to the master, a copy of the deed, and our power of attorney that we received from our conveyancer. The master then stamps that, and then we can proceed to lodge in the deeds office with that stamped copy of our power of attorney, together with our certified copy of the deed of sale and our usual documents we lodge. Important to note with our section 42.2, of course, is we don't have to wait for advertisement in terms of section 35. So we don't have to wait for our L&D account to have lain for inspection or finalized or accepted by the master. We can transfer much earlier in the administration process to recover any funds that is required to settle a shortfall in the estate. What if the property is jointly owned? So it does often happen as well that once the property lands in the estate, the deceased is not the only owner in that property. You might have a spouse that has a share in the property or a third party that has a share in that property. What do we do then with that additional share of the property? Does the executor still have the authority to elect to sell that property or to transfer that property in terms of the will without the consent of that third party, who of course also has an interest in that property? So there is a specific section that we look at here, and that is section 21 of our Administration of Estates Act, and it outlines exceptions to when an executor can deal with the property without the input of a third party. So if there is a joint ownership in the property, the second owner will always be involved, the third party owner will always be involved when it comes to administering that property, not just the deceased executor. However, there are certain instances where the executor can deal with that property without approaching that third party. So we're going to look at those specific exceptions right now. As a general rule for joint ownership, if one co-owner passes away, the executor is responsible for managing the deceased share only of that joint property, and he has to approach that third party owner for the second share of that property or the third share of the property, depending how many shares that third party owner or owners have. And then typically the deceased share must be transferred according to the will or the intestate succession rules, but the third party is not bound by the deceased will or the intestate succession rules. So with section 21, we have exceptions where the deceased does not have to approach that third party. And that's when the deceased share is only the deceased share is being transferred. So when the executor is only dealing with the deceased half share or third share, depending on the circumstances, he does not have to involve the other owner. He can transfer only that share, either in terms of section 42.1 or sell off that share in terms of section 42.2 without the consent of the other owner. An important one is if it is to settle debts. So if we are dealing with a joint estate and they need to settle debts, they can sell that property to settle any debts in the estate without getting the other owner's consent. When we are dealing with massing of an estate, so if we have two estates that have been massed and the surviving spouse is adiated, the transfer can proceed without the involvement of the surviving spouse, which might also be a third party or the other owner in the share of the property. Of course, if we're transferring to the surviving spouse and the surviving spouse is the other owner in the property, there's no need to get the consent from the surviving spouse because the remaining share is just being passed over to the surviving spouse, who will then have full ownership in the property. And again, if the surviving spouse is the co-owner in the property and the surviving spouse has signed the power of attorney already, there's no need for the surviving spouse to sign any of the other documents to transfer that property either to a third party or in terms of the Section 42(1) in terms of the will or the Interstate Succession Act. Okay, so important to note when these exemptions apply, it's only the executor acting and only the executor needs to sign the required documentation in terms of Section 42(1) or 42(2) to pass transfer of that property to either the heirs or the third party, and there's no involvement from that co-owner. Only in terms of the rules in terms of Section 25(1), any of these rules do not apply, then the co-owner needs to be approached to also sign the documents that we submit in terms of Section 42(1), 42(2). Okay, so now a quick example. Like we've mentioned, we just did some background on the legislation that we look at, how that legislation applies in both the administration process as well as the conveyancing process. At LexisNexis, we did, of course, put together a workflow between products that's going to assist you in having a better experience when following this property transfer process. So first off, I'm going to show you our deceased estates module, which will of course assist with drafting your reporting documents and your liquidation and distribution account. But beyond that, it will help you with any fixed properties you have recorded to send that through directly to our Lexis Convey platform with all of that information intact. So there's no need for you to recapture any of that information and then start off the conveyancing process either side by side or as soon as you are ready to push that through to the conveyancer. So let's just run through our scenario quickly. We've got John and Mary, who are happily married out of community of property for 25 years. They had 2 children, David and a daughter named Sarah. And unfortunately, John has passed away. They left 2 assets. We've got 2 properties in the estate, a family home and a holiday property. And they've left the properties, one of the properties to the surviving spouse and an equal shares to the children as well, the other property. So let's see how we capture that in Lexis Deceased Estates and how we transfer that information over to Lexis Convey in a seamless process. So we have all of our documents in order when it comes to the point to submit to the master and deal with our Section 42(1) transfer to the heirs, or when it comes time to sell the property and deal with our transfer of that property in terms of Section 42(2) of our Administration of Estates Act. So I'm just going to jump over quickly. Once we get there, apologies, there we go. There we go. So I've got Lexis Deceased Estates open on my side now. George, can you see my Lexis Deceased Estates on your side, or is it still stuck on my slide?
No, Gavin, I just still see your last slide.
Okay, let me just reshare quickly. Apologies. There we go. Do you have a view of Lexis Deceased Estates?
No. Yes, there we go. It's open now. Thanks, Gavin.
Perfect. Thanks, George. So in Lexis Deceased Estates, I've gone into one of my matters. For those of you who haven't seen the full product yet, it's worth reaching out for a demo. It's really a user-friendly product that's going to help make your administration process a lot easier. For purposes of this webinar, I'm just going to look at our fixed properties. So we, of course, in Lexis Deceased Estates, start capturing our matter with all of our necessary details relating to the master's office. We capture all of the details relating to our deceased, the spouse, and the children, so our next of kin. Quite user-friendly. We simply input our fields and indicate to the system how to deal with our next of kin. We list our executors' details as well as our beneficiaries. It then produces our reporting documents for us, but my aspect of dealing with property in the liquidation and distribution account comes from our liquidation and distribution account. So once I go into our L&D account over here, you'll see under our assets portion is, of course, where we'll load our properties. I've preloaded those already for us over here. So you'll see at the top here, I've got my ERP 1, 2, 3, 4 loaded. which we've got our ownership share percentage captured here, our property type at the top. We then describe our property in our fields over here and complete the value of our property at the bottom, as well as our beneficiaries that will inherit this property. So of course, you can see this property can always either be inherited or sold. If the property is marked as inherited, we know we're dealing with a section 42(1) because it's going directly to our heirs. If the property is marked as sold, it's going to a third party. So we know we're dealing with a section 42(2). So we've made this process very simple for you guys. You'll see at the top here, once we load a property, we've got an option to create a convey instruction. So if we click the button at the top here, next to that property, you'll see we've got all the details of our property listed at the top, which we can verify. We then simply, from a drop-down list of attorneys who use Lexis Convey, choose the attorneys we'd like to appoint, whether it be our own attorney's firm or another attorney's firm. We simply select that attorney's firm, and we can choose to send them the instruction to start dealing with the processing on the conveyances side of the transfer, or we can save and send it later if we're not yet ready to send that instruction. So if we have to wait for the L&D account to lay for inspection, for example, we can hold off for a bit. But for now, let's just send it through directly. And that instruction will then go through to Lexis Convey, to that conveyancing attorney's inbox, with all of the information we've captured in Lexis Deceased Estates already populated on Lexis Convey's side. So you know you're dealing with the same information on the administration process side as the conveyancer is dealing with on the transfer side, and just making sure that there is no discrepancies in the information that we submit to the deeds office and the master's office that might lead to delays later on in the process. So we can double check here on the left, on the right-hand side, we'll have a little convey button just to make sure that that property has been sent. So we can see that property has been sent through to convey, just verify those details. And we can then also send additional information from Lexis Deceased Estates side. So say for some reason the sale gets cancelled or the transfer gets cancelled, we can cancel that and advise the conveyancing attorney to no longer proceed. We can send through documents from Lexis Deceased Estates, either from within our matter, which we've uploaded, or directly from our PC, either by drag or drop, by dragging and dropping the files over here and sending that through to the conveyancing attorney directly. And we can also send through free format messaging that will land directly in that conveyancing attorney's Lexis Convey inbox for them to read and keep them updated on the administration process. So of course, we need to show you guys what that looks like in Lexis Convey side as well. So I'm going to hand over to Judy for a bit to show us what that looks like, and then I'll take back over to show you how we receive that information back into Lexis Deceased Estates. So I'm going to stop sharing my screen and hand over to you quickly, Judy.
Okay.
Don't see anything yet, Judy.
No, just hang on, it's disappeared off my screen.
Okay.
No, it's
While Judy's accessing her
no,
page there, just remember, please, to look out for the poll, which will come up shortly, and be sure to complete that for us, please. It's quite important. And I just want to say, while we're waiting for Judy, there are a number of questions that have come in, and we will certainly try and address most or all of them towards the end. So please, if I haven't replied to your questions, don't stress. We'll get to them. There's some common thread questions that are running, so brace yourself, Gavin. They're coming your way just now.
I'll be prepared though, George.
Thanks,
Okay.
Judy. We can see now.
You can see me.
Yeah.
Thanks. Okay, afternoon, everybody. So when I log into Lexis Convey online, it defaults to our homepage. And remembering the homepage is where we receive all our incoming messages from various parties. And you can see there's my transfer right at the top because it's instruction that's just come in. But down the left-hand side, you can also use this filter if you wanted to actually only maybe see transfers or only wanted to see bonds or specific banks and things like that. So you have the filter on the left-hand side. So it's always advisable to ensure that your filter is clear here to make sure that you've actually received everything that you need to receive. So in this instance, there's my instruction that has come from Lexis Deceased Estate, and I'm going to accept the instruction. A single click on it, it asks me some details. So that's the reference that's come in via the gateway channel. There I will put in my file reference from my file number and who's the person that's going to be assigned the matter. You'll select from your drop-down list of our references, and it selects the branch for the firm. It picks up the correct milestone process, and it roughly picks up when we are doing the ERD, but you can change that at any point. You can preview and look at the instruction beforehand, not really necessary. If you've got an existing matter already captured in Lexis Convey and you want to link this electronic message to that, you can click that button that says Connect Matter. We'll go and find the manual instruction and make your manual instruction then the electronic one, so you can continue to communicate back to the deceased estate administrators. This instance, I'm just going to now accept the instruction. It's busy accepting the instruction and going to default me to my Matters tab. When we go to the Matters tab, we'll then see that instruction sitting there. Just waiting for it to accept. It's creating the new instruction and it's pulling in all that information that has now been, was sent to us. So there's my file, there's my information. You can see defaults right to the top. Once again, before I go into the file, just be aware you've got this view on the left-hand side here. So you can determine what you'd like to see on the right-hand side. So for example, by matter types, you can say I only want to see transfers for this particular instance. And remembering once again to clear the filters at some point as well. And there's lots of other different ways I can look at my files. I want to only see my matters, maybe I can choose a specific reference. I don't want to see everybody else's, or I only want to see one branch instead of two branches because I've got more than one branch. All right, so when I hover over this matter, before I click on it, you'll see how there's some items at the bottom here that I can automatically do without actually opening the file. But when I single click on the file, it actually loads the matter for me. And then it can take me to my milestone summary page. And there you can see the date I received the instruction. And these are the various milestones that we would update. If I go to transfer details, yes, all these fields are already completed that I've now accepted from the instruction. There's the deeds office, there's what type of property it is, there's the cause of action. It's already picked it up. And then I would just go and complete the few major fields that I need for conveyances for PA, as we currently do now. There's the property description already pulled through. That's just typo on the system. It would come through like that as per normal. There's the expected registration date. There's the purchase price, the valuation of the property. Automatically all pulled through already. Some very little basic details come in on the correspondence tab. But as I'm generally capturing, normally I would go and capture more of the details here, but here's my two accordions with details already, and I would just go and complete the fields that I need. If the dates, the email address and cell number was captured in LDE, it would have come in here as well. And do the same for my transferee. Single click on my accordion, drops down the accordion, single click on the accordion, closes the accordion again. The transferors tab, there's all the detail regarding my deceased estate, my deceased details. There is the deceased, the High Court. And I click there, it drops down a whole lot of information. Once again, all of this coming in from LDE. And I would really just be 100% sure I'm happy with this information. Anything that I might need to add in, I can add in. And then the beneficiaries would load over here. So I'm just going to show you on another screen the beneficiaries in a minute. And then there's my transferee. In this instance, it's the two children that are inheriting the holiday home. There are all their details. Right, when we go to the SARS tab, once again, not having completed anything yet, the system does certain of the fields for me already. And I would just go through as normal practice and ensure that everything else is captured correctly. But there are my transferees and transferors, on my SARS tab already. And I go to the Documents tab now. So I'm just going to go back to the matter the first matter that was sent on this instruction. Here is the one that I received earlier on the first property. And it's going to take you to the Documents tab there. Sorry. Documents for signature. So once again, there's various ways. You can either scroll down and look for the document you're looking for, or in the filter at the top, you can just type in part of the document and it will go and search and find the documents that you want. So there's the section 42.1 that Gavin has been talking about. And if you have the Lexis Convey helper downloaded, you will have a preview button. But in this instance, I'm just going to download the document quickly and show you the document that it downloads for you. Already completed with all the information. Okay. I'm just going to go to the milestones and send some messages. So I already sent a message earlier on free format message. I can add extra wording to my message and send it. I can say a couple of days later, I want to tell the deceased estate administrator that the transferee has signed the documents and that I have received rates figures. No need to send and receive or do anything else. It's automatically doing it in the background. And now if Gavin opens up LDE, we will be able to see all those messages being received in LDE directly. Over to you, Gavin.
I'm sorry, I was on mute there. Thanks, Judy. It's great to see how all of that information is pulling through accurately onto Lexis Convey as well. So we're assured that we don't have any discrepancies in our documentation. I'm just going to share my screen again. Can you just let me know when you have a view of that? Say I'm on Zoom now.
No.
We can see Zoom, Gavin.
Let me just close this one off. I have so many tabs open here, it's like my mind.
Maybe,
Right.
Gavin, while your screen is loading, Judy, can I ask you a quick question?
Sure.
Of one of the questions that came up on the screen was the view of Convey, of Lexis Convey that you showed there. Was that the online version, a new
Yes, that was the
version?
online version.
There we go. I think that answers the question then. I don't have the question in front of me anymore, but I think it was
Yeah.
Mr. Cox. Yeah.
So just to clarify there, George, whether you're using online or the desktop
Yes.
version, we can still share the instruction through to the desktop version as well.
It works exactly the same way on both platforms.
Yeah, so just to quickly, before we showcase just how those notifications come through, I think we're just going to pop up the poll quickly before we get to our questions as well. If you guys can just take a quick few seconds just to answer that poll for us. Perfect. So you'll see once we get a message back from Lexis Convey, if you are inside of your deceased estates, at the top here, you'll see there's a new notification telling you exactly which milestones have been completed and which transfers have been accepted on the conveyance's side. If we also want to read our messages, we can open them up from here. They'll take us through to the messages. Or if we're outside of our matters, on the left-hand side, you'll see we have our LexisNexis products listed here. Lexis Convey is one of those products. And in our inbox, we'll see a message in terms of this transfer that has been sent. And we can read those messages over here as well to keep updated on the matter and also update our administration beneficiaries and stakeholders on exactly what the process is on the conveyances side. So that keeps both parties updated on where they are in the process, minimizing those delays that we often face if we aren't aligned with where we are in the process. That was just a quick preview. I see we only have a minute left, George. So
Yeah.
I'm going to ask that you just pose those questions so we can get through as many of them in the time frame we have.
Yeah, thank you so much, Gavin. Thank you, Jamie Lee. Thanks, Judes. That was really, really fascinating. And looking at the questions that are coming up here, I mean, there are a number of questions, and some of them I can't really address. A lot of people, a number of questions come up, regarding the interpretation of wills, for that matter, the interpretation of the Interstate Succession Act, a number of scenarios people have given on the screen. It's not really the place for me to be able to reply to all of those. So to those people that have asked like elaborate interpretive questions, forgive me. I'm going to focus on the questions that were quite more relevant to today's topic. And there are a few. So Gavin, one of the most common questions that came up was the case where people can't get consent, where they don't get the consent from all the other heirs or beneficiaries in a matter. Do you have thoughts on that, Gavin?
So yeah, I did see there were a few questions on that. Some of them pertained to the actual sale of the property. Some of them pertained to a lifelong right registered over the property where they can't get that heirs consent. Some of them pertained to
Yes.
the use areas that need to be sold separately. So the process in all of those are quite similar. So even though the executor has the authority to elect whether they want to sell the property or transfer in terms of the will, that sale does need to be consented to by our beneficiaries in order to get the go-ahead from the master, like we've seen when we went through our Section 42 processes. Even when we are submitting to the master only has a supervisionary role to ensure compliance with the process. The master cannot force one of the beneficiaries to sell the property or to disregard their lifelong right or their limited real right in the property. So in those instances where your beneficiary is not willing to consent to the sale of that property, even if it is to cover the debts in the estate, you can't approach the master for a resolution there, and the executor can also not overwrite, even though he has authority, he can't overwrite the decision of those beneficiaries or heirs. So your best approach there, if you find that that beneficiary is being unreasonable or they're not willing to contribute the amount of the shortfall that's needed to cover and pay your creditors, your best approach there would be to approach the High Court. And you'll have to take it to the High Court, where each party will have the opportunity to state their case, and the High Court will then make a decision either forcing that beneficiary to consent to the sale or not allowing the sale to go forward. So the best approach there is then to approach the High Court.
Yeah. Well, I can just imagine the moment you see the cost implications of going to the High Court, you'll probably get a settlement pretty quickly and some consents will
So
be signed,
that's
I'm
usually the
sure.
case in practice.
Yeah. Gavin, I know we're over time, so those that are still with us, thank you. I want to go back regarding 42.2. There were a number of questions regarding fees. Now, I suppose it's my fault because I started off by saying the first thing you do is you look at the fees you're going to make.
Yeah.
Be that as it may, there are not prescribed or fee guidelines for conveyancing matters. When you do a 42.2, the work that is associated to that, is that included in the conveyancing fee, or is that a separate fee? And if it is a separate fee, does the estate pay that, or does the purchaser also pay that? So assuming you have a deed of sale for $1 million, the purchaser must pay the costs of the transfer according to the deed of sale, but it's an estate transfer. So that extra work, is that a separate fee, or is that included in the ordinary conveyancing fee?
So that's a good question, George. So obviously there's a distinction between the Section 42.1 and the 42.2. With the 42.1, we are dealing with a transfer within the estate to an heir. So in those instances, we don't have a third party involved. We don't have an offer to purchase, which will guide us on who's responsible for those fees. In those instances, they will be settled out of the estate. The estate will cover those conveyancing fees, and they will be in terms of the conveyancing fee guidelines, which are published yearly. So your best solution will be to look to those guidelines, depending on who the heir is. If we're doing an endorsement transfer, we have separate fees. If we are doing a transfer to an heir, which is a full transfer, you'll look at your purchase price to determine what that fee is. With the Section 42.2, of course, we're selling to a third party, so we have an offer to purchase. In most instances, the offer to purchase will direct that the purchaser pay the conveyancing fees. So the process in terms of the conveyancer side will be covered with those conveyancing fees by that prescribed conveyancing fee, and any additional process on the disease administration side of things will be covered in the executor's fee. So whether that's the standardized 3.5% or a different fee that is regulated in terms of the will, that will be covered in terms of the executor's fee if the executor needs to apply to the master, say, for example, for consent. If the executor's fee, the master finds that the executor's fee does not cover the effort that it takes to do those applications to the master's office, you might apply to the master's to say, listen, the fee does not cover the work that it takes to get these additional consents. The master might direct that you ask a larger portion of the fee. But if it's at a set 3.5%, it's unlikely that the master will allow you to charge a higher fee. So if it's on the conveyancing side of things, there's no additional charge. It will be either in terms of your offer to purchase or your prescribed fee guidelines. If it's on the administration of estate side, it's usually covered in that 3.5% that you are entitled to of the gross value of the estate.
Yeah.
Aren't any additional fees you can add onto that. The master won't consent to those additional fees being added unless, of course, the 3.5% does not cover the effort it takes to complete that process.
Yeah. Well, I get that. Thanks, Gavin. I mean, we're way over time now, but there's still lots of people in the room. But I'm sure we all need to dash off somewhere. But Gavin, there's another question I want to ask you. It's not directly relevant to today's conversation, but it is in a way. Can you maybe remind us what the situation is regarding sales before the death of the testator? So the guy signs the deed of sale,
Yes.
and then there are two scenarios after that. He either has or hasn't signed the power of attorney yet.
So that, of course, is quite a straightforward thing. In practice, not as straightforward as it goes through theoretically. But of course, once the deceased passes, the executor steps into the shoes of the deceased. So if that contract has been perfected, the sale agreement has been perfected. In other words, the sale agreement has been signed and the suspensive conditions have been met. So if there's a bond that needs to be registered, that has been the bond has been approved on the purchaser's side, then that agreement has been perfected. The executor then steps into the shoes of the seller or the deceased in this instance, once the executor gets appointed, and then he has an option to elect whether to uphold that contract or to no longer continue with that contract. If the contract has not been perfected, then of course not upholding the contract is not going to have any additional implications. But if that contract has been perfected and the executor elects not to proceed with that contract, there might be a claim for damages. So that's always a consideration on the executor's side as well. But if the effective date of that sale is before the date of death, it's unlikely that we'll follow section 42.1 or 42.2 if that contract has already been perfected.
Yeah. Gavin, thank you very much. I think that wraps it up. I think I want to have a sort of a closing comment from my side also, is that there is a lot of interpretive things here, and interpreting the deed of sale is certainly one of the things, and interpreting the Interstate Succession Act, interpreting the Administration of the Estates Act, interpreting the Deeds Registries Act, all of those things come together, and of course interpreting the specific nuances within the sections as well. So a lot of questions came up, which I think ask questions around all of that, but a lot of that is very, very case specific and interpretive specific. But it isn't all that simple for anyone, and it's a complex field. And Gavin and Jamie Lee and Judy, I want to thank you for taking us through this and simplifying it and showing how the technology also simplifies these processes. That's really, really lovely to see. Most important are the attendees today. Thank you so much, everyone, for joining today. Watch the space. There is more to follow. And thank you very much for your attendance, and we wish you all a good afternoon further. With that, we're closing from our side. Thank you very much and good afternoon.
Thank you, everyone. Have a lovely day.
Bye-bye.